cases today in the order as they appear on the calendar. After the first case, we're going to take a short break and invite those here to join us in the Lawyers Lounge on the third floor. You can take the stairs of the elevator for coffee. The first case, excuse me if I mispronounce the name of the appellant, is it Breazeale or Breazeale?
It's Breazeale.
Breazeale, okay. Counsel.
May it please the court, I am Mike Chesser from Shalimar, Florida. My assistant counsel is Tara Hagan, also from Shalimar. Mr. Jeff Burns and Rick Peterman are here from Fort Walton Beach / Shalimar, and they represent the appellee. I'll request that I have 5 minutes in rebuttal after the presentation in chief. This is a case in which a condominium building was delivered 9 months later than the 2 years provided by its contract for sale within which it was to be completed. The building was offered to the purchaser, Mrs. Breazeale, who is the appellant here, again 9 months after the 2 years had expired. She responded that the building was completed too late. She said, "You have breached your contract, and I can't, and I shouldn't be required to purchase it."
Counsel, the issue here, it seems to me, is the provision in the contract that grants an extension to the 2-year time based on whether there were delays caused by events that constitute impossibility of performance.
That's correct.
But more basic than that, the contract calls for the completion of the unit within 2 years. But the contract doesn't define unit. Does that term mean that the unit can be completed when the condominium building is not?
It does not.
And why is that? It seems to me the rest of the contract does make references to the building and the condominiums, and the law and the statute makes reference to the completion of the building.
Sure. The word unit is defined in several ways in Chapter 718, but it seems to me clear that that word is used, and in fact it is defined as being the unit together with the undivided elements that are conveyed with a unit. And by definition in the statute, whenever the word unit is used, it is not just the space that a purchaser is intended to occupy, but whatever its common areas and other attendant facilities are. That definition is provided by statute.
So if I understand your argument correctly, it really doesn't matter that the local building official issued these temporary certificates of occupancy and ultimately the final certificate of occupancy, because by statute this transaction could not be completed because some of the common elements pertinent to this unit had not been completed.
Maybe, but perhaps being a little more refined with that statement, there are a group of temporary COs in this case, all of them issued about April the 27th, 28th, 30th. And there is some testimony that that's all of the temporary COs constitute all of the COs issued. There is the building official from Walton County who said, I don't think so. He said one of those temporary COs said, well, we are awaiting the construction of the common facilities, the lobbies and other things. The building official, though, took the stand and said the certificate of occupancy was issued on June 11th. We believe, and in fact, you'll remember the pictures that were submitted to the court, to the trial court. Those pictures showed the building without its stucco, showed the building without its common areas being enterable, and in fact, they were barricaded and under construction all on May 7th. And the trial court, and if I may, I'll go directly to that point to say that we believe the building was finished on June 11th when the final certificate of occupancy was issued. At that time, this unit was completed, and all of its common areas were likewise completed.
Well, as I thought I understood the surveyor's certificate that was filed or signed on about May 1st, it was that everything is complete except certain common elements.
Except, that's exactly right. Which takes us to the argument that I made in the brief and that I believe is applicable here. And that is the trial court, after testimony, required that both appellant in this case and appellee submit a proposed order. He got a proposed order from both of us, and he signed verbatim the proposed order submitted by the plaintiff in the case, the developer. That proposed order had a portion of Florida Statute 718-1044. I believe I'm giving you the right section. There is a two-step test provided in that statute. The first step is that the building be actually completed. And it says not only the unit, but the building and its common areas be actually completed. And then it says, in addition to that, there is a need for a certification from the surveyor that there is substantial completion of all of the facilities, the landscaping, and other things. In this case, the developer provided at trial the certification of a surveyor, saying there is, quote, substantial completion. That substantial completion, he said, had exceptions, and his exceptions were the stucco on the walls, the tennis courts. Those exceptions were made by the surveyor. There was never any attention given by the trial court, we think, to the first prong of that test, which is that the building and all of its attendant facilities must be completed. There is not the first set of an evidence in this case that there was actual completion of this building.
Let's assume that on the date that surveyor signed that certificate, the final CO had been issued. I know it was a different day, but let's assume that had been done. Assume the building was complete. By statute, by the 104 statute you referred to us, could that transaction have been completed because the surveyor said there are certain common elements that are not substantially complete?
I think not. An excellent question, but I think that buyer and seller, had they met at the table and said, let's do it anyway, they could have done that. They could have conveyed title, although that ignores the fact that there's one very important party left out of that discussion in most units, and that is the mortgage company that has a right, it seems to me, to understand that that building will be completed when that conveyance occurs. The fact that buyer and seller get together and make an agreement to the contrary probably is not determinative of the statute, which requires that the building be completed. This court understands, I am sure, the standards of review. We have suggested that the court was just clearly erroneous in its application of law to facts in this case in two ways. The first is the court made the conclusion that this building was completed, substantially completed on May 1st, that this unit was completed on April 30th. There were pictures of this building showing the lobby that was barricaded and inaccessible on May 7th. There were pictures that showed the building did not have its exterior coat stucco on May 7th. There is no indication except the testimony of Billy Bearden, who was the building inspector for Walton County, who said on June 11th, the final certificate of occupancy was issued. We believe that all of the evidence shows that on June, according to the Florida statute, on June 11th, the building was finished.
If that's the case, then the issue they put forward, or the trial court found, was that the deadline for completing the building in the 2-year period was extended to June 28th.
Yes, he did.
So, accepting that fact, as I know you don't want us to, but if we were to accept that fact, would the evidence that the final CO was issued on June 11th mean they win?
Yes, I think so. We believe the building was completed on that day. The developer has said, thank you very much, but now we have this delay expert that they brought to the court and said we're entitled to 251 days of delay. And you remember that he testified, we challenged primarily two areas of that delay about which he testified. The first was, he said, we're entitled to 30 days of delay before this contract with Mrs. Breazeale was ever signed. And we asked the question, Why is that? Well, that is because he says it took us longer to get our contracts with the contractor than we thought it was going to. They also said, incidentally, that we could have put more than 2 years in this contract had we wanted to do it. We chose not to do it. And there is no testimony, absolutely none, that they were not completely aware that they didn't have a contract with a contractor when they signed the contract with Mrs. Breazeale. That is 30 days that they claimed before they ever even signed a contract with Mrs. Breazeale, and they say we're entitled to tack that on. They also claim an additional 186 days. You remember that testimony?
Now, let's go back to the standard of review. The trial court accepted that 30 days. Isn't that a factual finding? Hasn't the trial court basically made a determination that as defined in the contract that there is this event would support a defense based on impossibility of performance?
I asked their delay expert exactly that question, and he said, that's not for me, that's a question for the court. And I believe he's right. I think it is an issue of law. The cases that we've cited include the Florida Power case, a 1944 Supreme Court case, the Harvey versus Lake, an 11th Circuit 2009 case, the American Aviation case, 1998 case. In each of those cases, the state, and I'll just read you just a quick excerpt from that. To excuse non-performance of a contract on the ground of an act of God, there must be, even in the absence of statutory provisions, no admixture of negligence or want of diligence, judgment, or skill on the part of the promisor. It must be the sole proximate cause of the non-performance without the participation of man. I point out to you here that this is a very narrowly drafted, a somewhat narrowly drafted, excusable extension clause. It says impossibility of performance due to matters beyond the control of the developer. And then it goes on to limit, to list some exceptions, some examples. Unlike most of the language you see, wherein it says impossibility of performance, and it gives a whole list of things that it could hear, it says impossibility of performance due to matters out of the control of the developer, and examples include. This is a much more limitedly drafted, we think, exclusionary language. I have 3 minutes and 30 seconds left. With your permission, I will reserve that for rebuttal. We believe this evidence is very clear that this developer should have known when he chose to overpour 176 caissons on which this building was built. He chose to do that because he was located in knee-deep water. He was located in knee-deep water, and we think this evidence is absolutely clear and could have predicted that. We think the law is absolutely the same for both of these issues. If you know it's going to happen and you don't do anything about it beforehand, you sign a contract that says 2 years, that 2 years is consequential for our client. Consequential, obviously, for theirs. 2 years go by, and there is no particular effort made to get this job done. Now, our point on this issue is that these caissons were overpoured by 4 feet, but they had every reason to know. The very reason they did it was clear to all the parties before they ever did it. And once they overpoured the caissons, they knew it was going to take some time to do it. Watch for the fact that in this testimony, we asked the witness, suppose it had taken 300 days. Well, I'd have given them 300. Do you mean to say you didn't look to see whether or not they worked expeditiously to finish this? He said, that was not my issue. My issue was how long it actually took, in this case, 186 days. I asked him specifically, had it taken 300, would you have given him that? And his answer was yes. Thank you very much. I will reserve the balance for rebuttal.
May it please the court, I'm attorney Jeffrey Burns, appearing on behalf of the appellee, GDC View, LLC. Seated next to me is Richard Peterman, who is trial counsel for the appellee. And I'm going to go ahead and start by covering a few of the facts that were covered at the end of the appellant's counsel argument. And the first being Ben Nolan supposedly giving any days that the contractor had asked for. The quote cited to in the briefs that the appellant relies upon is taken out of context. And certainly if you take that one little quote and you put it in a newspaper, you would think that's what Ben Nolan had given everybody. But if you read all the testimony surrounding that quote and additional testimony that Ben Nolan gave later on, which would be found in Volume 3 of the trial transcript, because I believe that's cited through testimony found in Volume 1, he explains in great detail the process that he went through in arriving at his conclusion to give the certain amount of days to the appellee. And not only did he include a very detailed description that lasted over 25 pages or so of trial testimony, he also included 700 pages of reports that was entered into his evidence supporting his basis. So
let me turn your attention back to the first issue they raised, and maybe it's my naivety on condominium law, but it seems to me, and help me understand if I'm wrong, that there's a different rule that applies to completion of condominium units for purposes of transfer that applies to just a regular property. And I guess it goes to my question of counsel whether the certificates of occupancy, temporary or permanent, were enough in light of the surveyor's certificate that said one of these common elements is not substantially complete. So help me understand where I'm misunderstanding, if I am.
Actually, you do bring up a good point. You're referring to, I think, 718-1044E. If you look at the language of that statute, it doesn't say the building has to be absolutely completed. And the language actually says all improvements, including but not limited to, and it gives limiting language after that point in time. There hasn't been a case that's ever actually, I guess, covered that statute and construed it in any way. But if this court were to actually apply the doctrine of expressio unius es exclusio alterius, which stands for the proposition that when a law expressly describes the particular situation in which something should apply, an inference must be drawn that what is not included by the specific reference was intended to be omitted or excluded. If the court looks at that certain language within the statute, it'll see it says all improvements including but not limited to. So then it limits all improvements to the building. And the list that it gives are landscaping, utility services, access to that unit, and common element facilities serving the building in which the units are to be conveyed. And here, the surveyor certificate did exclude a few items. It excluded Unit 100, which is not a common element. That's a commercial unit. So if Unit 100 would have been conveyed that day, it shouldn't have been conveyed, and it wasn't. But that's outside the factual record. The next point is dealing with the stucco. The stucco was only missing off one wall, and that's reflected on the surveyor certificate and the pictures that the appellant provided at trial. That's one final little stucco coat of paint. That's a punch list item. That's not a common element facility serving the building. That's not a utility. That's not access to the unit, and that's not landscaping. That's a punch list item that eventually got finished, but that's not covered in the statute. And the last item is the tennis courts themselves. These tennis courts were located on the top floor of the parking garage, which was a separate facility located right next to the condominium unit, not the building itself.
Were the tennis courts not common element facilities?
They're a common element. Are they a common element facility serving the building? I think that would be the question. And
what about the parking lot?
The parking lot, it was completed, and that provides access to the building, and the surveyor certificate says access to the building is provided.
So the parking garage, you're saying, was completed?
The parking garage was substantially completed, and that's the key language in the statute. It doesn't say completed, it uses substantially completed, which doesn't mean 100% completed. It means most of the way completed. And the parking garage...
Well, there are two places there. First, the statute says completed units within each substantially completed building can be conveyed, provided that all planned improvements, including common element facilities, are first completed. So you've got substantially completed at the beginning of the sentence and first completed in the middle of the sentence.
If you keep reading, though, Judge Van Ortwijk, it then sort of repeats itself in the next sentence and states that, let me find the language right here, And it says, provided that as the units being conveyed, there is a certificate of a surveyor and mapper as required above, including certification that all planned improvements, including but not limited to landscaping, utility services, and access to the unit, and common element facilities serving the building in which the units to be conveyed are located, have been substantially completed.
I guess that's my concern, though. When you look at the surveyor's certificate, it says expressly that the wall above the parking deck is not substantially complete. And if a wall that is part of the parking deck, which is serving the facility, is not complete, then how can it be substantially complete, even under your interpretation of the statute?
Well, the wall itself was complete as the stucco coating on the wall. And he did expressly exclude that, but I guess if you were to use this limiting language in the statute, it doesn't say all punch list type of items. In a final coat of paint, I mean, if you look at the stucco in and of itself, it was not substantially complete on that one building. But the wall itself is not what he talked about right there. He talked about the final stucco coat on that wall. And that's analogous to if you were to have a sign on the side of Grand Dunes that said GD, and you didn't have the GD sign up there. Is it substantially complete because you didn't have the GD sign painted? I don't know.
Well, isn't that a factual question? I mean, for the surveyor to determine what is and is not substantially complete. I mean, I'll take the tennis courts, for example. If everything was finished except, the tape on the net was not put on, and he wrote, it's substantially complete, and they disagreed, would have litigation, and the trial court would make a finding. Here, the surveyor, in his own affidavit, said these things are not substantially complete.
And he did. But I think if you read the statute, it doesn't say every single item in the entire building has to be substantially complete.
So your limitation you would ask us to adopt is
It's the
common
doctrine.
element. It's not every common element